Hi, everybody. Ray Dickey from South Carolina CAI, Hudson Valley CAI, and Association Help Now. We are covering many states. This is a very important topic. The success of your project depends on the proper RFP. And I will throw it out there that is 100% accurate. The success of your project does 100% depend on the proper RFP. Everyone has a question feature today. Please use it, send comments. I absolutely love it. I don't use people's names when I relay the question, so feel free to ask whatever you like, but don't send me anything too top secret because I could make a mistake. We do things a little differently now because a lot of these programs are available for CEU on-demand videos. If you are here for CEUs, use that question feature and enter CEU. Use that question feature and enter CEU. That's how I'm able to tell the governing bodies that you were here and prove so. And we'll have to do this a couple more times today. If you're watching the recorded version in particular, you absolutely definitely need to do that to get your CEU. So please pay attention. All right. With that being said, let's have our panel introduce themselves with who I see first, and that is Greg.
Good morning, everyone. Greg Girelli with Girelli Insurance Agency. We're located in Cold Spring, New York. We are a family-owned independent insurance agency that has a department working with insurance master policy programs for community associations throughout the Hudson Valley and surrounding tri-state area.
All right. And you know what? I want to ask you a quick question, Greg. I ask everybody in the panel. How do you get your exercise? Very quickly.
I do a lot of outside work, yard work. I like working on cars, and I'm just very hands-on.
And you go skiing a lot.
And I ski a lot.
If anybody in the audience wants to share how they get their exercise, I'm just curious very quickly. Corey, please introduce yourself.
My name is Corey Kravitz. Thank you for having me again today. The managing principal of Kovich, Schifrin Nesbitt's Florida office. We're a national community association law firm with offices in Florida, Illinois, Wisconsin, and Indiana.
How do you get your exercise?
I try to hit the gym every morning, at least for a half hour.
I believe you. All right, John.
John Legumina from the Legumina Law Firm in Purchase, New York, just outside of New York City. We represent condominiums, co-ops, and homeowner associations from New York City throughout the Hudson Valley areas.
All right, John. So how do you get exercise?
Same as Corey, Jim.
Okay. Dave.
Good morning, everybody. My name is Dave Byrne. My law firm is Ansell Law, and I'm the chairperson of our Community Association Practice Group. We represent condominiums, HOAs, co-ops in New Jersey, New York, and Pennsylvania.
Do you consider sports betting an exercise, Dave Byrne?
Not a physical one, no.
How do you exercise?
Mental exercise if you prepare correctly.
Do you exercise?
Mentally or physically?
Physically.
Yes.
Okay, he's obviously. I'm done. I'm moving on. Okay. Dave Chesky.
Hi, good morning, everyone. Dave Chesky, Executive Vice President of Falcon Group. We are a full-service engineering and architecture reserve study firm serving community associations nationally.
A lot of people putting down running, gym, biking. Oh, someone's training for a 1/2 marathon. Very impressive. Let us know how you did. I would like to know how you did. I know that you're on the live stream quite a bit, so thank you for sharing. All right. The success of your project depends on the proper RFP. Greg, I was saying before we went live how strongly I feel about this. Please get the audience excited about this topic.
Oh, the details of the RFP are very important. We're going to get into each aspect, and they definitely will affect the outcome of each project. When it's prepared for and documented properly to start, it's going to make the whole process go a lot smoother.
Corey, please get people excited. There was another aspect that I told you before we went live about how RFPs are similar to.
I don't remember. I wasn't.
I feel like you aren't. I feel like you're not paying attention to me. That's very obvious during the intro. Contracts. We were talking about that.
Yeah, it's like it's kind of like an LOI almost. You know, you're putting, you know, the basic terms of the deal together. So it's a very important, and especially, you know, the most important part is it allows you, when you're reviewing reviewing other bids, to compare apples to apples.
I meant you screw this up, you're going to have a problem. Correct, John?
Yep.
Okay.
That's correct.
And Dave Chesky, you love RFPs because that's part of your business, correct?
Huge part of our business. Yeah, we call them specifications and bid forms, construction drawings, which are essentially RFPs.
Why do you have to call it something different than everyone else? Because you're an engineer?
Because, we're engineers.
All right, let's talk about scope of work. Dave Byrne, what is the scope of work?
The term, I think, identifies the precise boundaries of what the contractor is going to do or be contracted to do, which creates then a legal, the legal scope of what you could hold the contractor to. So at the end of the day, if something wasn't contemplated or included in the scope of work, the contractor didn't have an obligation to do it.
You are correct, Dave. For a second there, I thought you were hesitating.
AI, I'm correct. I equal what AI told you. That's
well, I am getting to trust AI more and more, but we just did a thing how I shouldn't. So yesterday. All right, Dave, anything to add? This is right up your alley, Dave Chesky. Anything to add to the scope of work? This is a kind of a critical kind of point in the RFP or not?
It is. It should define the method and materials in detail, not only for contract purposes, but also for that for that bidding process, to make sure you're getting bids on an apples to apples basis. If you bid it out to 5 different contractors, you want them all bidding on the same materials and the same method, so you can have a comparative and competitive bid process.
Corey, Dave just mentioned something interesting I think we should backtrack on. Why can't I just have AI do my RFPs nowadays? I mean, it's so amazing. Why do I need to call Dave Chesky on my multi-million-dollar project? I could save some money.
I think you're still better off with the people who have their hands on the pulse of the industry. Everything's changing on a daily basis in terms of prices and materials. And people like Dave have the contacts and the actual networks to get you the best prices.
So Dave Chesky, bring it home. Why don't we use AI?
Well, that's like asking AI to do your taxes. You're not going to do that. You're going to hire an accountant to do your taxes. You're not going to ask AI to do them, or for any other professional services. You're not going to ask AI to do it for you. I mean, you need that expertise. Every situation, every condition, every building, every site is going to have its own unique situations, details, requirements, and you really need a hands-on, visual, human approach to determining what actually needs to be done there for the benefit of the owner.
And Ray, I'll chime in real quick. I think you can't sue AI if there's a mistake. So in a sort of real sort of down to the bare bones approach, like Dave Chesky said, you hire an accountant to do your taxes. So if your accountant puts the number in the wrong place and the IRS charges you $10,000 in interest, you have someone to hold accountable for the mistake. It's the same thing with the RFPs. If you hire a professional to prepare an RFP and the person uses the wrong engineering code when it's prepared, you have someone to hold accountable. If you just go on the internet and have some, computer, Terminator guy do it, cyborg do it, then you'd have no recourse.
You made it very exciting, Dave. Good imagination.
Skynet. I was looking for Skynet. That's what I was looking for.
We just got done talking about how this is like a contract. So I think if you don't want to use AI for your contracts, why would you use AI for this? I think that would be absolutely crazy. Someone in the audience is commenting, John could never have AI do his taxes because he owns properties in multiple countries. Yes, that is true in the audience. You have learned about John actually has a team. It takes 12 people to do John's taxes, and it's this big. So, because he's very, very, very wealthy, very wealthy. All right, timeline and schedule. Corey, attorneys are familiar with RFPs, right? Why don't you backtrack a little bit? I'm sorry. what is an attorney's role in an RFP? Why do you guys know about them?
They're often sent to us to review prior to projects going out to bid, to make sure it's, not missing anything. Or when the contract comes in, we compare what terms of the contract to what's on the RFP to make sure that, everything on there is in there. In terms of timeline and schedule, super important. I got a call from a client this week where they went under contract for some work 4 years ago, and it's still not done. And so, there's the contractor attorneys need to make sure that the contractor can be held accountable if projects go on forever, or if they never get completed, or have an avenue to terminate, get your money back, and move on to another contractor.
Dave Chesky, I think I'm going to say this a lot today. This seems like one of the most critical aspects of an RFP to protect an association. Is that true?
I mean, it is a critical aspect. You want to set boundaries and schedules, and have realistic terms in the contract for this, because there's lots of things that could affect timeline and schedule, like weather and conditions, unforeseen situations.
John, are you going to put a bunch of penalties in here if this protects the association, right? If the project is late and it causes harm to the association, is this something an attorney is going to jump into?
Yeah, so depending on the work and the project, but it's often appropriate to put in, and really I'm going to use them as not as penalties, but really an incentive to get the work done on time. And if you don't, every day that you're beyond the deadline, there's a price to pay.
Greg, we haven't gotten involved with insurance yet, though, right? None of these aspects?
No, none of these are insurance, although the scope of work definitely could come into play. But insurance is going to be a huge part of the RFP when we get to that topic.
Okay. The scope of work would come into play because it's just kind of like a general statement and it could impact the insurance. Is that why you said scope of work may?
Yes.
Okay. Dave Chesky, instructions to vendors. I don't know if the vendor's supposed to know what they're doing. Why do we have to have instructions, and how detailed should they be?
Well, that's really the methods, right? I said methods and materials earlier. The instructions are the methods, details, depending on the type of work, whether it's a roofing project or a siding project or a roadway resurfacing project, there's going to be different ways to do that work. And we want to make sure that the contractor is doing the work properly and appropriately, and is taking the material off site or whatever needs to be done to make the site safe or to do it the way it should be done. We want to make sure that that's written out in the specification.
Dave Byrne, this could also mean instructions to the vendor on how they're supposed to submit their RFP. True or false in commentary?
Yeah, I suppose. The RFP thing for me is always challenging, because I'd prefer my RFPs that are done to be devoid of contract language. I'd like them to focus exclusively on the scope of work, the service. From a practical standpoint, when a contractor gets an RFP, he or she's bidding on the scope of work. If you include contractual terms in there, like insurance requirements and all these other kinds of things, correctly, I think the vendor is bidding on those. And then when it comes to be quote unquote contract time, there's a lot of misunderstandings when a lawyer starts to modify certain things and make them different than that was in different from what was in the quote unquote RFP. So that's just a quirk of mine. I've over all these years, I find that to be very challenging when RFPs include contractual language as opposed to simply just what you're supposed to do and how much it's going to cost.
I feel like it could be challenging to do that, Dave, for yourself, right? And I'm going to go to Corey and John on this also, right? Because you have an obligation. You guys just told me that an RFP could tie into a contract, right? So you have some legal issues you need to make sure in there. Yet, Dave, you're telling me you want to keep it simple, right?
Yeah, I think sometimes they'll send these RFPs out and they're like signature lines on them, which means if it's signed, it's a contract. And then you oftentimes get a lot of boards or managers. They'll come back and say, okay, the board awarded the contract to XYZ company. Please prepare a contract. You're like, you already have a contract. This is a contract. I mean, even especially if it's signed by both parties as a contract, but it's done as a contract. It's like, if you look at it, it's drafted as a contract. So there's a misunderstanding out there, I think, with the idea that somehow an RFP isn't a contract and that there's a second step. There only is a second step if you create a mechanism that follows that process. That just could be my view and my experience. I mean, other lawyers may feel differently. It's certainly okay to have different opinion. That's just how I feel.
Corey, that sounds like a great idea to me. It sounds like it'd be a lot easier for the board members to understand it and everyone else. It seems difficult. You'd have to be a really good attorney to make that happen. And I'm sure Dave is a very good attorney. But Corey, commentary.
No, I agree with Dave completely. I think the RFP should be very simple. They really, depending upon the scope of the project, if it's a landscaping contract versus, a renovation project, some need detail in terms of materials, depending on the scope of the work. But really, the simpler the better, because number one, people don't want to read 10-page documents, and number two, leave the legal side, like Dave said, leave the legal side to the attorneys, and focus on the scope of the work, because that's what's going to be compared.
So John, does the legalese, if that's even a word, of the RFP go hand in hand with the complexity of the project? Is that accurate?
I mean, so I agree with Dave and Corey. You're better off segregating the scope of the work, and it could be drawings. This is where you say, this is how you, for example, this is what the roof is going to be comprised of, these materials in this fashion, and so this way that we'll call that the work, right? But the actual, like, payment terms, what constitutes a breach of contract, leave that for the lawyers. It's easy enough to have, if you have really good specs, detailed specs, to simply attach them to and if you want to save money, you attach them to, there's a lot of form contracts, AIA, American Institute of Architects, they have forms that are pretty good. So it's not like don't think you're saving money because you're having the engineer prepare the contract.
Dave Chesky, what have you seen? I mean, obviously you see a lot of these. So what's your opinion of this?
Yeah, I mean, it depends on the scope, right? Of what the actual work is. If it's a landscaping contract, or if it's a small cost contract, or I'm sorry, small cost RFP, then it should be pretty basic. We tend to include things like insurance requirements and schedule, and like even that the contractor is required to supply a portable toilet on site, to that level of detail, because sometimes it doesn't go to the attorney. We don't know whether or not it's going. We always recommend that it does, but that's up to the board and the association whether or not they get a contract or not. Many times they'll send it to their attorney, and the attorney just drafts like a addendum to the general requirements, to define the specifics of any additional language that should be included in there that's not addressed in our general requirements, or even revising some of the requirements in our general requirements.
So Corey, I can see this really quick as like a cost savings issue too. Like, you should keep, if you hire a new attorney, maybe you've not used it before, and you start getting back an RFP that has a whole bunch of legal content, you may be paying for a bunch of stuff that you don't need. Is that accurate?
Or it could be wrong. If you're using AI to put the legal content in, it may be citing incorrect statutes, or I've seen a whole gambit of crazy stuff lately with the AI. So yeah, I keep it simple, keep your costs down, and I think the message of today is to focus on the scope of work.
Okay. Don't worry, Greg. I know insurance is involved in this, like, big time. Vendors, Greg, why don't you touch upon that? I know that's a major insurance issue.
Well, I just want to address with what we were talking about, the insurance can really change the pricing of a contract from the vendor standpoint, the contractor
Right.
that's doing the work. So if you don't outline whether a $5 million umbrella is required for this job or not going to be required for this job, you definitely could mess up the RFP and the bidding process if you don't set some parameters on what insurance and what expectations are taking place. And mainly, obviously, talking about larger jobs than a much smaller RFP for a landscaping project. But you definitely want to watch that, because that will blow up between the RFP process and going to the attorney that I didn't contemplate in this part of the insurance, and that's going to cost the contractor an extra 60 grand or 100 grand.
For most RFPs, Greg, is it a best practice to definitely send it to your insurance rep?
I believe it is. And in general with these, once you send it to the insurance rep and it's for a maintenance, repair, or a construction type contract, generally those terms for insurance, they're not going to change much unless you have a huge variation of the project. So once you decide these are my contractor requirements for insurance to work on our property at our association, that's not something that necessarily has to get reviewed 5 times a day. It's going to pretty much stick through, but you want to be consistent with that because it can really change the bidding process.
And your insurance rep is not going to charge you for that, for the most part.
Correct. And then we can get into the actual coverage aspects, because it's shocking the number of times we see the contractor awarded the bid is not actually covered to do the work that he said he was going to be doing.
So it sounds to me like it would be crazy not to send it to your insurance rep. If it
Correct.
doesn't cost you
And
anything.
we resolve a lot of those issues.
I also think, even though you don't want to admit it, you guys can pick up on other stuff sometimes that, and not that that's why people are contacting.
Correct. You're supposed to focus on the insurance section though. Yes.
But RFPs. You do.
We see a lot of them. Yes.
Really quick, I want to get this out of the way. If you're here for CEUs, you need to click enter CEU. Dave Byrne, you don't need to do it. You're not here for CEUs. Neither is John.
Definitely not.
Neither is Greg. If you're here for CEUs, enter CEUs. I need to do that for CMICB. Don't say I didn't tell you. Don't say I didn't give you plenty of time to do it. If you're here for CEUs, go ahead and do that, especially if you're watching the recorded version. Okay. All right. So evaluation criteria. Dave Chesky, why is this in here? What is it? What does it mean?
In what context evaluation?
I love when I have a slide and I go to the panel and they have like no idea what it is, because obviously I'm just taking, this slide's been around a long time.
I can't really see the slide either. I can't
know.
ever see the slide. I can't,
Oh.
the box isn't big enough for me to see the slide.
That might just be your screen, David.
Yeah, it's your screen,
Maybe.
Dave. Everyone else
Just
is telling.
telling, I'm just laying it out there. Just telling like it is.
Okay, well, thanks for
Keeping it real.
sharing.
Keeping it real. Keeping it
I'm
real.
sorry
brother.
I'm sorry you can't see it. Thanks for
Keeping it
sharing.
real.
Evaluation of what? Bids?
Hold on, I'm gonna read my notes. I have notes on everything.
Oh, okay.
I do work kind of hard at this. Define the criteria that will be used to evaluate the submitted proposals. This could include factors like experience, cost, technical capabilities, past performance, and compliant with requirements. So I guess they're talking about evaluating the RFP or multiple ones.
Yeah, so when you go out for competitive bidding, you get bids back. You have to evaluate them for to make sure there's no errors, to make sure that the contractors are capable and qualified to do the work. Typically in a set of specifications or a bid form, we would require a contractor reference sheet so we can check references, similar projects. Depending on the work, we'll ask the contractors to provide an equipment list to make sure that they have the proper equipment. We'll ask if they're going to include any subcontractors on the work, because we want to make sure who else is going to be brought in on the job and whether or not they have the proper insurance requirements and all other requirements. Some projects might require bonding. We'll ask for bank references. We need to vet these contractors and make sure that they're qualified to do the work that's specified.
Dave, will an engineer ever just evaluate an RFP, or do they actually need to be managing the vendors? Dave Chesky.
Managing the vendors, meaning like watching the work?
I think
Observing
they're
the work in
asking
progress?
like, I have a project going on here. It's a good sized project. You have nothing to do with it. Besides, all I want you to do is evaluate the RFP. I don't
We
want you to
can.
be involved in any other way.
We can take a look and give an opinion. that's what it's going to be, is an opinion.
Why are you hesitant about that? It seems almost like having a third party look at it would be maybe a little bit more safer than having somebody that has a skin in the game.
It's just that the design, what are we evaluating based on? The scope of work is not going to be specified, so it may be difficult to evaluate it based on that. But whether or not the contractors are qualified to do that specific scope, it really depends on what exactly is being done in terms of scope, and how there's lots of things that could determine the viability of that work.
Yeah, you don't want to have to do an entire investigation to give an opinion on something that's so complex that you weren't in the process in the beginning, basically, right? You're also probably uncomfortable because you're relying on other people's work, I guess, to a certain extent. I don't know. That seems like
Right.
what
or a scope of work that's so open-ended, and we might just come back and our opinion might be this is way too open-ended, and there
Right.
could be lots of change orders and lots of extras and things like that, and it becomes an issue.
Greg, what is bonding?
Bonding for the job, you could end up with a bid and performance bond. So the bid is if you are awarded the bid and for some reason you didn't meet the requirements for the bid, the association would be able to go against that bid if the contractor went and disappeared on the bond. And then a performance bond is going to be based on you meeting and following through that whole scope of work on the bond, that you'd have a performance bond for the amount of the job. And if you failed to meet that, it's the financial aspect for the customer to go after for you not meeting that contract.
And this is insurance, right, Greg? You get this through an insurance company,
Yes.
correct?
Yes.
This seems very important to me to have this in certain cases. Do you agree?
Yes. Yes. This is on the contractor's insurance. So this is insurance a contractor is going to get, not something the association is going to be able to obtain.
Dave Byrne, is this something that gets overlooked sometimes, or do you think, I mean, if you're not using an engineer, obviously if you're using an engineer, this is a prime example, they're going to catch it, but the average person that tries to do this on their own, do you think they overlook this, Dave Byrne?
Well, in my experience, performance bonds are overlooked because they cost $1 gazillion. I mean, they're not practical in the real world. When you're doing repairs on the New York Thruway or on the New Jersey Turnpike, you get contractors to put up performance bonds. Performance bonds guarantee the work, the quality of the work. That's not what insurance is. Insurance is to provide coverage for accidents, things that happen. Guy drops a piece of steel on his foot, that kind of thing. That's what insurance is for. Performance bond is like, if the work isn't done correctly, the performance bond company has to hire people to fix it and finish it. That's not what insurance is. So the cost disparity is remarkable. I mean, most associations can't even would not be able to afford a performance bond. It'd be unrealistic to ever even try to get one. In my view.
Corey, opinion on performance bonds or commentary?
Yeah, typically our associations only do it for massive projects, if it's, $1 million or and above, maybe, because of the price. And that price, and that's something to put into an RFP, is whether or not the association is going to require a performance bond.
Right, because the bid will be a lot higher, right?
A lot higher. It's not the contractor paying for it. It's the association ultimately paying for it.
Right. John, commentary?
Yeah, so, I mean, it used to be, any substantial contract, you should think about getting a payment bond or a performance bond. But Dave's right, they're so expensive that I would say, like, unless you're doing $1 million worth of work, it might be cost prohibitive. They're not cheap. They're great to have because you have actual money. I'll give you a really common example at condominiums is usually, and it's the developer gets it. They post a bond with the town to, if they, at the end of the job, if they fail to do the top coat of the road, the town could take that money and do the top coat of the road. So that's kind of like an example of it. But for most condo projects, it's going to be cost prohibitive.
Dave, who is going to, I mean, this seems complex, right, Dave Chesky? whether or not a board should get a performance bond, because we're always talking about they have an obligation to protect the association, but then it's a lot of money. How can boards go about evaluating whether or not they should get one, or can they not, and they have to maybe hire someone like yourself?
Yeah, I mean, they have to evaluate the scope of the project, the cost of the project, and whether it makes sense. Do they have, engineering involved? And what the payment terms are, how the payment terms are laid out. Because if you lay out the payment terms, well enough, there is some protection afforded there. Make sure the contractor is not ahead on payments, not ahead on the work versus the payments, and always hold back a retainage. So there's monies there for addressing any issues that might come up after the work is done, or again, the payment schedule maybe should be laid out so that there's progress payments and the contract gets paid only for what work has been done, and there's no payments ahead of time.
Greg, why are insurance agents so greedy when it comes to performance bonds? No, why don't you give me the last word on performance bonds, because everybody just kind of like gave them a hard time a little bit.
As Dave kind of alluded to, bonds really aren't insurance. They're a financial tool. And when a contractor is going for a bond, the tax documents, financial forms, and the financial strength that contract has to show just to even be eligible to obtain a performance bond is so
Good
strong.
point.
It eliminates many of the contractors. And then you do get to the price point on it, because a lot of bonds do end up paying. The price is very exorbitant. So we definitely don't see them as many on association projects.
And well, one of the reasons why we ask contractors for performance bond, whether or not they have a bonding company, we don't necessarily ask them to provide the performance bond or the cost of it unless it's specifically requested. But because of what Greg just alluded to, that's why we ask them to provide the bonding company, because of the strict requirements for the contractor to be able to obtain it to begin with. That just kind of signifies that the contractor is qualified and capable.
Correct, Dave. Just being eligible to obtain a bond shows a lot of financial strength for the contractor.
Dave Byrne, the audience wants to know if you're running a copy center today, because you seem to be doing a lot of folding and stapling. We're all watching you. You're doing a lot of collating.
I have a mailer to get out today.
Okay, yeah, I didn't know if you're out of the legal business and you're running a.
No,
I don't know
I'm
if you're
just
running a
teasing.
copy center on the side right now, because you're obviously very comfortable doing your copy work and folding in front of us all. So we appreciate it.
Michael Scott is over there, and he wants me to finish my assignment.
Budget and pricing. Budget. Corey, I mean, I don't know. Is this a legal aspect? Should I be asking you about it? Should it be in there? I guess it should. You take it.
That's probably more of a business aspect
Yeah.
For the firm, to make sure they can afford the project and how they're going to pay for it. But it can be a legal aspect in terms of how it's going to be paid if a special assessment needs to be raised in that, to that effect.
And I know, Dave Chesky, these all involve you. I'm just kind of saving you for last here. I just jump to you, Dave Chesky, on this. This is something also, if it's a complex project, you're going to have a qualified professional involved, I assume.
Yeah, well, part of laying out the scope is laying out the bid items that would be priced, depending on what scope it is. And a lot of it can be unit price based. And you want to hold the contractor to the cost that they are bidding on over the course of the project. And even if it's a lump sum bid, you want to make sure that becomes part of the contract. And that's stated in the RFP clearly, that the contractor is providing these services for X amount of dollars. And that encompasses all the work. There could be, items in the scope that are, if and where required type of work items. Again, the contractor would provide unit prices for those specific scopes or specific materials or what have you. And then those costs would need to be kind of upheld through the process of the project.
Okay. Dave Byrne, can you mute? Because you are so noisy today. Oh my gosh. I meant just with the
I don't know.
clicking.
I'm not doing
I
anything.
meant,
Really?
I
Clicking?
meant it is so distracting me with the clicking and
Hmm.
everything. Okay. Budget and pricing, contractual terms and conditions. John, legal, and legal, correct?
Yeah, I mean, contractual terms and conditions, that's what you have your attorney for. And again, best practices is you could look to the AIA form contracts, and they have very good terms and conditions. So importantly, how are you going to pay the contractor? Are you going to have what they call as retention or retainage? So you're going to hold back 10% at the end of the job. Another important aspect, are you going to have payment requisitions? Are you going to have, so they're called like progress payments? We pay you as you go, but you got to show how much you did. And then if you have an engineer and architect, they have to sign off that you actually did that. Those are best practices, retention and progress payments. So those are among the important terms.
And Greg, I'm going to go to everybody on this one, but the insurance falls under this, right? I guess, because it's a condition.
Sure. If you don't have a separate slide for insurance, then yes, the insurance you want your lawyer to put together, but he should work with a licensed insurance agent who knows community associations. And then that's going to really vary in many ways. I'm going to talk about New York for a second, where obviously each state or each territory could have different insurance issues. We have scaffold law, labor law, where there's a height problem where you could have a contractor has insurance, but he's not covered for his employees falling. We have issues where we've had contractors been awarded a roofing contract. However, they're with an insurance company that excludes roofing work in New York State. So you need to, one, make sure the terms are clear in the contract so when they're accepting it. And then even after it, you want to make sure the insurance agent reviews the certificate that comes in. Now, the certificate may only be good for the day that we see it, but at least make sure that the company and the forms are covering the type of work that is being done.
I think the insurance is so important in this, Greg. I really do. I mean, I think the insurance is critical in an RFP. Do you? I mean, you obviously agree, right?
I agree. It is critical, but it's usually the afterthought, and it causes some contracts to blow up afterwards because it wasn't communicated well back and forth.
Someone is asking, are you uncomfortable talking about insurance unless there's an insurance slide behind me?
Yes, I didn't think I was supposed to bring up insurance. I didn't want to get yelled at for talking about insurance when it says contractual terms.
You've done too many of these now, where it's become like it's traumatizing now. Unless I put up insurance, I'll make sure. I figured insurance involved everything, so I figured you would like jump in and out throughout the entire thing. One thing I don't have a slide on, which somebody just sent me over, was, and I'll start with Dave Chesky because this is like a big item. Because at my building here, we're having a million things done, changeovers. And I kept hearing like the board was defending here at my building changeovers and percentages, and it's not too high. And if it's too high, you're not doing a good job with your contract. And you're always going to have a certain amount of changeovers. Can you talk about changeovers?
Change orders, you mean?
Change orders. I'm sorry. What did I say?
Changeovers.
Oh, sorry. Go ahead. Change orders.
Yeah, I mean, a change order is just that. It's something additional and extra that's unforeseen, that's not specified in the scope of work. They happen because of unforeseen conditions, but if the scope of work is tight and includes everything, change order should be minimal. But they do happen, and they need to be substantiated. You need to make sure that they're actually needed and not part of the scope of work.
Corey, one other reason I'm bringing this up. People here, residents always aren't nice, and they basically accuse people of setting in faulty proposals because there's a lot of changeovers later, right? They say if there's a high changeover rate, that it was kind of shady business with the original contractor. In some ways, that could be accurate, correct, Corey, to a certain extent?
I mean, the argument is that the contractor had, if you choose the lowest price or the lowest bid, that they're going to make their money on change orders. I don't think, maybe some do that, but I don't think that's the standard or the practice. I think most contractors are accurately trying to predict the scope of the work. But when they get into the project, they open a wall and the conditions that they were told were there or that they expected to be there are not what's on the ground. And that's usually what precipitates a change order. There's always the people who change their minds. They don't like the way something aesthetically looks after they've approved it and it's been built. But I think more often than not, you open up a wall and it's filled with mold or it's not what was expected.
So Dave Byrne, a lot of the changeover issues, though, I'm playing devil's advocate here, should be in the RFP though. But I guess theoretically you can't foresee every issue that could come up, but you should not have changeovers for items that should have been known during the original proposal, correct?
Yeah, I guess sort of outside of, I'm in my bailiwick, I guess. I know there may be particular jobs. I would venture to guess that when you do an RFP for an annual landscaping contract, I can't imagine you'd have many changes. But if you're dealing with a building that was a hospital built in 1940 that was renovated in 2010 to be a 200-unit condominium, and they left all the original stuff in there, and it's 100 years old, and you may not know what you have until you open up the walls. I mean, that to me is conceivable you'd have changes.
I'm going to go to Dave Chesky on this last, but John, the reason I'm bringing up the it's not changeovers, change orders, I'm sorry, is that this is a hot item at my building here. It seems like the board is constantly defending themselves in this regard and defending the contractors. And I'm wondering if it's common in our industry. Like, the owners really jump over these change orders. Like, I don't really have an issue with it for the most part. But do you find that also? Is this something that board should look at closely because they could get some heat for it?
I don't see it being controversial. I just think it's as Dave mentioned, it's best practices to before you sign everything, think it through, make sure you cover everything you anticipate, and change orders are for things that you're not anticipating. And so it's an agreement to agree, right? You still have, you want the ability to, as a board, to say, hey, you can't bill us for extra work unless we agree.
And Dave Chesky, Corey brought up a great example about you open up the wall and there's a bunch of mold in there. So I guess that doesn't need to be in the RFP, or it does. Like, what's the last word on the change orders?
Yeah, I mean, again, it's for unforeseen items or material changes to the scope of work. If those components or bid items aren't in the RFP, right? So the RFP could contain things like framing repair or insulation replacement, like if and where type of items that might come up as part of developing the RFP. But if it's something material that is a change from the scope of work or a material that's not on the RFP, then it's a legitimate change order. But again, it needs to be verified. It needs to be, you need to confirm that it's actually needed and confirm that it is additional to the RFP scope.
And this seems like an item that would be the responsibility of a board. I'm going to go to the lawyers on this. I mean, would a manager have the ability to approve these change orders on their own, or do you? I mean, I'm asking you a legal question, Dave Chesky. Sorry, I'll go to the lawyers. But generally, who approves these change orders? Can the manager do it on their own, or do they need board approval? I know it's a legal question, Dave Chesky, but what do you see generally?
Oh, me? I think it is, ultimately the board approves it, but the board needs a professional to, again, confirm that it is needed and it is above and beyond the prescribed scope of work that's in the RFP or specifications.
Okay. Dave Byrne, was Dave Chesky pretty close on his legal definition?
Yeah, I think so.
Okay.
I think so.
Does anybody on the panel disagree that this definitely, at the very least, needs to be reported to and reviewed by the board? The board should be aware of a change order. Okay, excellent, excellent. Vendor qualifications and experience. I meant, I'll go to Corey. The attorney, are they going to put a bunch of language in there about this, or are we going to leave this up to an engineer if they're preparing the RFP, or just leave it up to the board or the manager? Corey, what's the legal aspect?
Anytime I receive a contract, I always make sure a few things. One is the contractor licensed. In Florida, it's pretty easy to look up the licenses online. Is the company registered with the Secretary of State, which to make sure that if there is a need to file a lawsuit, we're able to do so. And sometimes we find that the contractor who's bidding on it is using somebody else's license. So it's we're not necessarily reference checking. We're making sure that all the I's are dotted and T's are crossed in terms of what their obligations are as a contractor are met legally.
There's a lot of YouTube videos out there of like newscasters, like reporters chasing like shady builders, and they don't have licenses, and they're doing exactly what you just said, use someone else's license. John, this could be a really shady business, construction, and I guess any business could, but I want to bring the audience back to the point where how important the RFP is and doing the proper research and having people have your back.
Yeah, I mean, so that's why I mentioned before, my biggest concern is payments, because I view this as if the contractor went AWOL, and it does happen, would you be in a good position, or would you be kind of screwed? So you don't want to, although I'm realistic, most contractors won't start a job without getting some money up front. But once you get going, I'm a big proponent of progress payments. Pay as you go. Don't really trust that you have a signed contract. You want to be either a little bit ahead of the contractor, or at least stay with it, so that if the shit hits the fan, pardon the expression, you could hire another contractor to step in and finish the work, and you wouldn't be out of pocket.
So Dave Byrne, this seems like a critical item that should be a big part of the RFP, right? Because also it protects the contractor. I guess everybody wants to know when they're going to get paid and not have assumptions out there.
Yeah, but I think, yeah, the answer is yes. I think the dynamic of this comes down to sort of what type of arrangement you have and what type of setup you have. Like John was mentioning before, I think, payments that are subject to, you submit a form and then they get approved and that sort of thing. That's generally what an engineer does. And that's when you have a job that you've hired an engineer to oversee the job. And that connects a lot of times with what John mentioned before, the AIA contract. You don't have to do it that way. Like if you generally see those things done on significantly large projects. But in that dynamic, you're actually authorizing the engineer to be kind of like a middleman, fair-minded arbitrator. He or she is not your advocate. He's the advocate for the job. So the contractor will submit an invoice. The board will say, wow, the contractor wasn't very nice to me that day, so we should hold back some money. The engineer is supposed to say, no, according to what I'm seeing, the work was done. You have to pay him whether you like it or not. So in some ways, depending on how you set it up, if you're setting it up so that the engineer has authority over payments, then the engineer has authority over payments, whether you want to pay the guy or not.
Hey, Dave Chesky, can you make a note? Because I want to continue with the payment thing with Corey and get Greg, because I was hoping you could offer commentary on how valuable it could be to have an engineer deal with the vendors on a regular basis than maybe somebody who isn't experienced dealing with, construction contractors. Corey, commentary on payments. It seems critical, so I want to make sure everybody gets in here.
Yeah. In addition to having partial payments, you also want to make sure that that the subs are being paid. No liens. You want partial releases of the liens for each payment. You don't want a situation where you're paying the contractor and the contractor is not paying the sub, and the sub's filing liens on the building. It creates a huge headache, especially if a unit owner is going to sell and there's a lien on the building, because they're the one who's going to have to pay their proportionate share to have that released. So that's a big deal to take into consideration.
Greg, do insurance companies ever take sliding scale payments?
They take payments on installments, yes. So they're usually a little bit ahead of you, but accurate. But yes, insurance companies obviously take payments. On this aspect, though, I definitely think vendor qualifications is a huge part. And Dave mentioned it earlier. References is a huge part of this because you want to know that contractor, if you're doing a huge roofing project, that he completed other roofing projects that were 10 buildings, 32 buildings. And, not everyone's going to be completely happy, but that he stuck through those projects and he's got experience relevant to the job that you're looking to do, and you're not his first large job.
I think, yeah, it's a great. I mean, I didn't even have references down, which is pretty terrible. All right,
Can I
Dave.
Yeah. With regards to what Greg's just said, the references I want to express the importance of that, because not only do you want to make sure the contractor can handle the scope and scale of the project, but in the community living environment, it's a different type of work, particularly with things like roadway resurfacing projects or even roofing projects. These are occupied communities. We can't just tell everybody to leave. Remove all the cars in a community with a one way in, one way out, setup. It's just not practical. So if you go to a contractor and the contractor's experience is based on milling and paving highways or municipal roadways, it's going to be a little different for that contractor to work within a community that's occupied, that needs to be staged, and it's much slower work. And there's not nearly the production that they'll see when doing the municipal or highway work. So you want to make sure that those vendors are specifically that those vendors have specific experience in the community living environment.
Dave, Dave Chesky, let me ask you this then. Here at my building, we have a high impact project going on. I'm on the 29th floor. All our outside decks have been getting done for the last couple of years. Our parking lot is getting fixed, or a parking deck is getting. There's a tremendous amount of contractors here, and they're literally right outside your door sometimes, right, working on your deck. I would say they've been excellent. I mean, I would say the impact, they don't play loud music, they don't use foul language. These are things that would have a major impact on the standard of living. It's hard enough having this going on here, but I would say these contractors have been so respectful, and they're even dressed appropriately. Is that something how can an association make sure that happens? Because that has a huge impact on what you just said. This project's been going on 2 years, and I really can't blame these guys here for making it any worse. They've made it as pleasurable as it could be, or, tolerable.
Yeah. I mean, that's part of retaining the proper qualified contractor that, that knows the proper, that directs their employees to, appropriate behavior on a job. Like, you have to keep your shirts on, you have to wear hard hats, there's safety requirements that they need to follow and adhere to. A qualified contractor is going to have that as part of their training process with their employees.
I just hope that boards for big communities understand this too, because I'm living with these guys for 2 years. I'm seeing them in the elevators. I mean, we have service elevators, but they're in our regular elevators a lot of times. You're running into these guys, and I say guys because they do tend to mostly be guys. I should say people, but we're living with them, and it's been about 2 years. And I have to say, I think they've done an excellent job as far as being respectful of the community. But, Dave Chesky, I can see that definitely being not the case. And boy, I would be pretty miserable if that wasn't the case. So, but that's critical, right, Dave? The engineer would be a big part of that, I guess, too. They would know which companies are good performers and which ones aren't performing.
Yeah, well, if you have an engineer on the project, then that engineer would be visiting the site and observing the work, documenting the work. And if they see something that is either unsafe or a condition that is inappropriate, like workers without shirts or blasting music or using foul language, they're going to say something and bring it up before it becomes a problem.
I know you're not in the insurance business, but should Greg Dorelli always wear a shirt when he's seeing a client? Would there ever be a circumstance? What about if he's seeing a client at the beach? Would that be acceptable for him to not wear a shirt if it was a beach client?
No, he should wear a shirt.
Okay. All right, really quick, support and maintenance. That should be, because I want to give you guys plenty of time for closing thoughts. Support and maintenance. Corey, any commentary?
Yeah, one of the things I was thinking about when we were just talking about, the people on the job, in our contracts, we always make sure to put in, the level of keeping the work site clean, where materials and tools going to be stored. Um, you know, I think those are also key things that should be in the contracts so that the work site is safe, and the homeowners are not disrupted.
I agree. I mean, if you're a board and you don't want to get elected next time, have, someone like myself having to live with a bunch of rude contractors leaving cigarette butts around and playing loud music. That has just not been the case here. It's just been excellent. And you know what, Corey, they do a very good job at storing their materials. And I think they do the best job that they could for such a large scale project. Contact information. Supposedly a lot of people forget this, according to the best practices of my research. I find this hard to believe. But I guess panel, I'll start with John. There's a lot of little stuff you may forget if you don't have a professional help you out. True or false, John?
No, there are. I mean, Corey mentioned it before, something as minor as check the Department of State site to make sure that the entity that you're contracting with is actually a organization formed in your state. You'll be surprised how many times it's something else.
Why is this in here, Dave Byrne? Why did I put this? Why did I make this stand out? I don't know why.
Well, the interesting nuance that John just answered and you guys were talking about too is like there are on a state by state basis, there's a lot of differences and there's really interesting things that you really have to, that a lawyer and I guess even an engineer would pick up on over time. Like in New Jersey, we have this thing called the Prompt Payment Act, which for 30 plus years of doing this, I don't think a contractor even realized existed. And now in the past couple of years, a couple of them have figured it out. But the courts have said that it can be negotiated away. So I slide a provision in my contracts that I use where the contractor waives any rights it may have with respect to the Prompt Payment Act. I use the citation so they don't look it up, because if they see Prompt Payment Act, they go, "Ooh, what's that about?" So you put the lawyer thing. There's designations the lawyers use to look stuff up. You put that in, so you can contract that away because that provision is pretty solid for a contractor. It allows for legal fees. It allows for other things. If a contractor sends you a bill and you ignore it, you're in trouble. You don't have to pay it. You just have to respond in a certain amount of time with why you're not paying it. And that's could be a pretty draconian statute, which a lot of contractors haven't figured out how to use yet. But these are the kinds of interesting things you can deal with in a contract. You can contract that away. Same thing like Corey mentioned before about liens. You can in New Jersey, at least, in Pennsylvania, you can contract that away. A contractor can waive the right to do that. But that's not something that will, if it's left out of the contract or if it's left silent, a contractor would have those tools available to it, even if you don't know they exist. They'll find out later. You know what I mean? These are things you have to know ahead of time to protect yourself.
What I heard, Dave, is you definitely want to use an attorney because you'll know all the attorney tricks to better protect the association that you're not going to know otherwise.
And and if your attorney doesn't know the tricks, then you'll have someone to call when it's screwed up.
All right, let me do a question really quick because I want to do closing thoughts. Shouldn't the major national property management companies have ready-made boilerplate RFPs for common standard contracts and also supply a list of vetted contractors to their site managers? It seems like our community is always starting from scratch with unknown vendors and incomplete contracts without corporate support. Very quick answer, Dave Chesky.
Again, I mean, it depends on the scope. If it's a landscaping contract, landscaping RFP, or it's a minor RFP, snow plowing or whatever, then yeah, I mean, it's probably a boilerplate contract that is used in multiple properties can be, used as a boilerplate. But if it's a large scope, large contract, then it needs to be site specific.
I thought they all had vetted contractors for the most part, the large ones. They're a preferred contractor list. Is that the same thing, Dave?
Yeah. Yeah. As far as contractor lists, yeah. I mean, they're contractors that are, again, involved in community living industry, involved in CAI. That's, management companies will have experience with them from other properties, and then they kind of take them along to, throughout all their properties.
Greg Dorelli, closing thoughts. You have 3 seconds.
When things go wrong on your contract, this is the first thing you're going to go and look at. So make sure you put the time and effort into it to begin with, that it's done right, because it's going to help you in the long haul.
You are good. Great job, I mean. All right, Corey, very quickly, closing thoughts.
I think the boilerplate and the management company references are a good starting point, but obviously those contracts before they're signed need to go to the attorney to either have an addendum done or be redrafted specific to that job.
Oh, if you can do the CEUs, I would appreciate it. CEUs, good time to check the CEUs right now. John, while this is up, closing thoughts.
My closing thought is don't hesitate to use professionals, especially an engineer or architect, when you have a significant contract. They could not only prepare the scope of work, but they could also handle the payment approvals process.
Okay, and once again, audience, do the CEUs if you need them. Use your question feature. Dave, closing thoughts. Dave Byrne.
Yeah, I'll tag off of John, which is that you know, consider using professionals, but I'll say also that not all arrangements are, and not all jobs are created equal. Some require a more intensive effort when it comes to the scope of work and the contract, and some don't. You know, yeah, some professional large or otherwise professional management companies should have a snow removal contract specification. I think the lawyer should still do the contract, but the specification for that, I would think you wouldn't need to hire an engineer for that kind of thing. But there may be a bigger job where it'd be a mistake not to. So you have to really look on a case-by-case basis, I think.
Dave Chesky, last word on today.
Yeah, it's all a matter of transferring liability. You want to make sure that you're, on those large scale projects, it's not only preparing the RFP and approving invoices, but it's also documenting the work. So if there's ever an issue later on in the future, if something was not done properly, it's documented. You have the information to either go back to the contractor with that would legitimize that issue and be able to take corrective measures on.
All right. Well, thank you, panel. Thank you, audience, for being here. Much appreciated. And I hope to see everybody soon. Thanks, everybody. Bye.
Thank you. Bye-bye.